The International Court of Justice is now in session. President Keith and the Moot judges Donoghue and co-presiding. Please be seated. The case before the court is the secession and annexation of East Agnostica. The parties are applicant, the Federal Republic of Agnostica, versus the respondent, the state of Reverentia. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
And for the applicant, counsel. Well, welcome to this hearing.
Mr. President, Your Excellencies, may it please the court. My name is Elisa Zavala, and it is an honor to appear today pleading on behalf of the Federal Republic of Agnostica. I will speak first for 22 minutes. Then my co-agent, Mr. Benjamin Salas, will present for 21 minutes, and we respectfully reserve 2 minutes for rebuttal. Also with us as our off-counsel, Josefina Movillo. Your Excellencies, this is a case of sovereignty. We stand before you today because Reverentia has continuously violated Agnostica's sovereign rights, who has consequently suffered a number of grievances. The respondent encouraged an illegal referendum, violated Agnostica's territorial integrity, and illegally annexed East Agnostica. Moreover, the applicant has not been able to fully exploit its natural resources since the respondent failed to recognize that the Marthite Convention terminated and because they illegally removed the software from the facilities. I will be dealing with the first and second issue, and my co-agent will deal with issues 3 and 4.
Thank you.
The first issue submitted by the applicant to the court revolves around Reverentia's encouragement of the East Agnostican referendum. In that regard, the applicant makes 2 contentions. First, that they violated the principle of non-intervention, since the requisites for it to apply are met. And second, that the cumulative effect of Reverentia's actions resulted in a violation of the principle of territorial integrity. Contrary to what the respondent defends themselves from in page 6 and onwards of the written submissions, we do not put forward to the court that the principle of the threat of the use of force has been violated. Your Excellencies, on January 9, 2013, President Nuvalus delivered a speech criticizing the Agnostican Parliament's decision to maintain the unity of its provinces and assuring to the Agnoreves, and I quote, "We will do everything in our power to ensure that you are indeed free." The following day, and as seen in paragraph 35 of the compromise, the Reverentian Parliament issued a resolution titled "On the Crisis of East Agnostica" that would allow President Nuvalus, among other things, to recognize a new state that could emerge by any means at their disposal. Finally, on January 18th, from that same year, Reverentia stationed several hundred troops in the border with East Agnostica after committing to take all necessary measures to ensure the integrity of a new state that could emerge. Your Excellencies, we submit that the principle of non-intervention was violated since the requisites for it to apply are met, and in order to determine this, we would like to point this court's attention to the Nicaragua decision, and acknowledging the differences between that case and the current one, because in the 1986 Nicaragua case, this court had to decide whether the support provided by the United States to the paramilitary groups was in accordance to international law, and in fact found that not only the principle of non-intervention had been violated, but also the threat and the use of force, we submit that the legal reasonings in that case can solve the present one.
So exactly when did the intervention occur? When did the illegality occur?
We submit, Your Excellency, that the three actions that were previously mentioned, this is President Nuvalu's speech, the resolution in the Parliament, and also the stationing of troops violated this principle.
So did it occur when all three had happened, or when the first happened, or when 1 and 2 happened? When did it happen?
In relation to the principle of non-intervention, we submit that independently, all of these three actions violated the principle of non-intervention, but in relation to the principle of territorial integrity, we submit that such was violated through the cumulative effect of reverential actions. And we put forward that the principle of non-intervention was violated because, as provided in paragraph 205 of the Nicaragua decision, the elements of an unlawful intervention is that it affects matters of domestic jurisdiction and that it is done through coercive means.
So a speech is an intervention?
We would submit that not any speech is an intervention, Your Excellency, but that this precise speech did amount to the lawful requisites for it to happen. If we see the matter in which it was regarded and also the fact that it amounted to coercion, we said that this precise speech did amount to an intervention. If we see, for example, what the General Assembly provided in its Resolution 36-103 in 1981, it was established that states should refrain from supporting secessionist groups abroad because this would violate this principle, and in recent conflicts, this same provision has been upheld. We see, for example, in General Assembly Resolution 68-262 that the General Assembly that the General Assembly called on the international community to refrain from making any statements that would disrupt Ukraine's territorial integrity. In the year 2012, similar provisions were taken in relation to the conflict in South Sudan. We see in the unanimously adopted Security Council Resolution 2046 that the international community was called to refrain from making speech that would disrupt Sudan's territorial integrity. And thus we submit that through speeches, the principle of non-intervention can be breached. This court should specially consider the fact that this was a matter of agnostica's internal affairs.
So, Counsel, does that mean that you're asking this court to find that any time that a state, through speech, supports the aims of separatists in a neighboring state, that constitutes a violation of international law?
Not precisely, Your Excellency. There are certain elements that should be present in the speech in order to constitute a violation of international law. First, we would say that in this precise situation, what was done by Reverencia was a support of an illegal secessionist process in the country. So, for example, we could draw a distinction from the support that some countries may have provided to the secessionist process in Scotland, because that was an legal process in the United Kingdom. And second, Your Excellencies, we submit that if we see that terms that are used in President Nuvalu's speech, that amounted to coercion. We would like to point this court's attention to General Assembly Resolution 2625, commonly known as the 1970 Declaration on Friendly Relations, which itself amounts to customary international law, as recognized in paragraph 80 of the Kosovo Advisory Opinion, that provides that any act can amount to coercion.
But you understand that you're asking us now this court, to spend a lot of time perusing a lot of speeches in the future. A speech conduct distinction is much easier to deal with than what you're describing. You're saying that certain words are intervention even if there's no chance that they will be followed.
Your Excellency, we understand what we're asking to the court may be difficult, but at the same time, we submit that when a principle of international law has been violated, and we submit that such is the case because the element of coercion is present in President Nuvalu's speech, this court should gravely condemn those actions. The previously cited 2625 resolution provides that any act can amount to coercion inasmuch it is designed to subordinate the exercise of another state's sovereignty. And we submit that that was what happened in this case. To provide a point of comparison, in November 2014, Catalonia conducted a referendum that was opposed by Spain's Constitutional Court. In that situation, the United States National Security spokesperson, the United
I guess
Kingdom's...
I'm puzzled why you're not arguing that when all three things occur, there's an intervention. Why are you arguing on this first point alone? You have a stronger case than that, don't you?
Your Excellency, the first submission of the applicant is that the actions taken separately would amount to a violation, but alternatively, this court could consider the cumulative effect of reverential actions, as has done before, for example, in the hostages in Tehran case, paragraph 91, in the Namibia case, paragraph 105, or in the jurisdictional immunities case, paragraph 106, where the cumulative effect that was taken by those countries was taken into account. But we do submit that the principle of territorial integrity was violated through the cumulative effect of their actions. If we see the progression of the facts of the compromise, we see that this is clear. On December 26, 2012, President Nubalus contacted Mr. Bien and offered support even before the Agnores have ever before threatened to secede. Later, they tried to exercise their constitutional rights, and just a couple of days later, as seen in paragraph 35 of the compromise, the Reverential Parliament issued a resolution where the word referendum is used for the first time in the compromise, even before the Agnores had decided to do so. That same resolution could be understood as setting a path of actions that could be taken by the Agnores, because it talked about recognition and about even unrestricted support with any means at their disposal. Finally, Your Excellencies, it is also the applicant's submission that reverential actions violated the United Nations Charter generally. The purpose of the United Nations is the maintenance, of peace and stability in the world. And this is a matter that should concern this court as the judicial organ of the United Nations, as recognized, for example, in the reasoning of the nuclear test case decision. Your Excellencies, in this situation, what is at stake is the international order created in 1945 to maintain peace and stability in the world.
When you refer, Counsel, to the United Nations Charter generally, what do you mean? There are 100+ articles in the Charter, aren't there, and some very broad principles.
We submit...
And perhaps I can combine that question with my colleague's question. Aren't you on much stronger ground if you take the accumulation of the events, the three events that you mentioned?
Mr. President, we alternatively do submit that this court should analyze the cumulative effect of reverential actions in the violation of these principles that were at stake. And in relation to the first concern that was raised by Mr. President, we submit that reverential actions violated the object and purpose of the United Nations Charter as a binding treaty that was signed by both parties, as seen in paragraph 44 of the compromise. We submit that this court should also condemn the breach of that treaty that was signed.
Thank you.
Your Excellencies, if it may please the court, I will now address the second question presented by the applicant to the court, which revolves around East Agnostica's purported secession and subsequent annexation by the respondent. In this regard, our main contention is that the respondent cannot rely on a right to unilateral secession in international law, since no source of international law recognized that source, and on an alternative, and should the court find that a right to unilateral secession exists in international law, it is our submission that the requisites for it to apply are not met. The respondent, on page 12 of the written submissions, rely on the doctrine of remedial secession or unilateral secession in order to justify East Agnostica's process. We submit that what was stated in the Island case in 1920 remains true, since until today, international law does not grant the right to separate from a state by the mere expression of a wish. First, because there is no customary rule in this regard, and second, because no other source of international law recognizes it as such. We submit further that if the respondent wishes to rely on a customary rule in such regard, it would be on their burden to prove that such exists. And we contend that that is not the case because the element of state practice is not present. And thus, the requisites for custom, which has been recognized by this court, for example, in paragraph 77 of the North Continental Shelf case, are not present. As ruled in the Anglo-Norwegian fisheries case, state practice needs to be at least substantially uniform for state practice to exist. But in post-colonial times, no state has emerged without the consent of its parent state.
Counsel, aren't you asking this court essentially to reduce the notion of self-determination of peoples to nothing?
On the contrary, Your Excellency, we would submit that what this court has to recognize is that modern international law prefers the protection of the rights to self-determination in its internal sphere, because that is what will maintain peace and stability in the world. The two main principles that are at stake in this precise case are the sovereignty of states on the one hand, and the principle of self-determination on the other. And recognizing the erga omnes character of the principle of self-determination, as provided, for example, in the East Timor case, paragraph 29, we submit that balancing these principles has already been solved by the international community, which prefers the protection of the internal sphere of self-determination, and thus would not allow secession for a people.
So just so that I understand it, does it then mean that anytime a state is democratic and has a minority, and there are constant referenda regarding independence, and the minority loses, there's no escape path for that minority? They're forever bound to remain in that state?
What we submit, Your Excellency, is that these situations can be solved if an agreement is reached between the minority and the parent state. As, for example, the conflict in South Sudan was solved in the year 2011 when an agreement was reached between the parties, but that contrary to that situation, this court should not grant a right to do so because there is no source of international law that recognizes as such. We submit, as was previously noted, that the respondent cannot rely in a customary rule since state practice is not present, but that in any case, there is no other source of international law that recognizes it. None of the treaties that were signed by the parties, as seen in paragraph 44 of the compromise, recognize a right to unilateral secession.
Who is it, if there was a right, and you're saying there isn't, but who is it who is exercising that right? Or who is bound on your terms by the obligation not to secede?
It would be the East Agnostican population, Your Excellency.
And international law then binds the people of Scotland or of Catalan or of South Australia, as we heard once in a case, not to try to divide, not to try to leave the larger country. So international law binds the population, you say, of the eastern province.
Mr. President, we submit that generally the issue should be solved internally, and thus it is a domestic state of the different states in the international community. For example, in the case of Scotland, a decision was taken between the United Kingdom's government and the population, and a referendum was legally held. But when otherwise is not the case, this would be in violation of the domestic regulation of states. And that further, if this court were to recognize a right to unilateral secession, that would be, of course, in that case, regulated by international law, we would submit that the requisites for it to apply are not met.
So a breach of national law can be at the same time a breach of international law, you're saying?
Mr. President, we submit that a right to unilateral secession does not exist in our main contention, so the only thing that would be lawful in international law would be reaching an agreement between the parties, but that furthermore, if this court were to recognize that right as existing, it would be possible to violate the domestic affairs of an state, but to act lawfully in the international sphere. Your Excellencies, according to those that defend the existence of the right to remedial secession,
If we order them to stay a part of Agnostica, what assurance do we have that that order would be complied with?
Your Excellencies, if this court were to find that East Agnostica did not have a right to secede, the only possible solution is to adjudge in reparations a restitution of that territory, and in accordance to the general practice of this court, what would be done is a good faith negotiation between the parties. We also see that the parties have decided to act in good faith by submitting this to the International Court of Justice. And as we see in paragraph 43 of the compromise, they met in New York in May from the year 2014 to negotiate the terms. And thus, we submit that if this court finds in our favor in this regard, this court should expect that both parties would reach an agreement and solve this international controversy, protecting the rights of the Agnews that would be at stake.
Counsel, we said quite recently in the Kosovo advisory opinion that the principle of territorial integrity is confined to relations between states. Isn't it difficult to reconcile that point with your assertion that international law imposes obligations on the population of a state not to secede outside of the constitutional strictures of that state?
Your Excellency, we would like to put forward 2 points of answer. First, what we submit to the court is that in this situation, the principle of non-intervention was violated by reverentia and not by the Agnews. But furthermore, and in the concern that was raised by Your Excellency, we recognize that that was established by the court in the Kosovo advisory opinion, but that in that same decision, this court provided in paragraph 83 that although they were not going to address the issue of secession because it was outside the scope of the question that was submitted, that secession involved the right of a people to separate from a state. And thus, it understood that it was a matter of law and that this court thus should recognize as such. Further, we submit, Your Excellencies, that if the respondent wishes to rely in the doctrine of remedial secession, the requisites for it to apply were not met.
Can I just ask about Mr. Navalis' speech? Was it protected by the International Covenant on Civil and Political Rights, his right to speak?
Your Excellency, recognizing that there exists in general a freedom of speech, of course, the rights have limits, and when there is, for example, an element of coercion, as was previously noted, we submit that that right cannot be invoked legally, and thus constituted a violation of international law. Furthermore, Your Excellencies, and dealing with the last issue at stake, the respondent could not rely in a doctrine of remedial secession because the main requisite is that there is a massive violation of the fundamental human rights of the people in question. If we see the standard that was set by the African Commission, both in its 1992 Katanga decision or in its 2009 Cameroon case, outside or when a massive violation of fundamental human rights is not present, remedial secession could not be invoked.
But
and
a lot of people called for Kosovo to secede, and they didn't know till many years later whether that would be held consistent with international law or not. So how do we know whether they were exercising protected speech or whether they were calling for something illegal that was an unlawful intervention?
Your Excellency, to answer your question, can I answer that question?
Please.
To answer your question, we would like to point the court's attention to the separate opinion of Judge Fitzmaurice in the 1962 Temple of Priavir case, where it was provided that in later times, the intention, state of mind, or attitude of a state could serve as good evidence for determining the intention, state of mind, or actions in a previous time, and this should especially be considered when the principle of territorial integrity is at stake. We believe that the annexation that later took place would serve in analyzing the previous facts. With this, I conclude the applicant's first and second submission and thank the court.
Thank you, Mr. Vala. And now, Mr. Salas. Thank you.
Good afternoon. Mr. President, Your Excellencies, may it please the court. My name is Benjamin Salas, and as agent for the applicant, I will spend the next 21 minutes addressing the third and fourth questions presented before the court. The third on the termination of the Maritime Convention in April 2nd of 2012 due to a fundamental change of the circumstances, and the fourth on the unlawful removal of the software from the maritime extraction facilities ordered by Reverencia. Now, addressing the first of these issues, I will first address the court on the lawful application of the rebus sixtantibus doctrine as the customary ground which terminated the Maritime Convention in April 2nd of 2012. And then I will address the court on how the prolongation of the Maritime Convention beyond that date would jeopardize Agnostica's sovereignty over its natural resources. Now, Your Excellencies, according to paragraph 9 of the compromise, marthite is a naturally occurring salt mineral which can only be found in the Thanatosian plains. In April of 1938, both parties concluded the Marthite Convention to regulate the exploitation and distribution of marthite in Reverencia and East Agnostica. However, in late 2011, a team of scientists from the ILSA reported that marthite was nearly 100% effective in healing early childhood autoimmune disorders.
At that time, was it foreseeable that it might have other medicinal uses?
Your Excellencies, even though Article 9 does acknowledge that marthite had mild restorative properties and that it was used as a medical component, we submit that there was no way to foresee that there was going to be a groundbreaking medical discovery to allow this mineral that would heal tens of thousands of children of previously untreatable autoimmune disorders.
So that was totally unforeseeable at the time of the conclusion of the treaty.
We do believe so, that it was unforeseeable due to the magnitude of the change. But, Your Excellencies, the change that in this case the applicant wishes to put forward to this court, which fundamentally changed the circumstances, is the increase in the economic value of marthite, which was inexistent at the time of the conclusion of the treaty in 1938, and now, after the medical discoveries from the ILSA, has raised in magnitude.
Counsel, you began your presentation by referring to the customary grounds of rebus sixtantibus, and I'd just like a clarification. Are you suggesting that there's a distinction between a customary standard under customary international law and the provisions of Article 62 of the Vienna Convention on Law of Treaties?
Your Excellencies, it is our submission in the present case that the rebus sixtantibus doctrine is customary international law as codified in Article 62 of the Vienna Convention. Now, since the Marthite Convention was concluded before the adoption of both states of the Vienna Convention on the Law of Treaties, the Vienna Convention is not applicable as such to the Marthite Convention, and thus it is necessary to rely on a customary right to denounce the termination of a treaty due to a fundamental change of the circumstances. However, we do submit, Your Excellencies, that the same requisites enshrined in Article 62 of the Vienna Convention are applicable to the present case, namely that the change has to be unforeseen for the parties, it has to constitute an essential basis for the consent of the parties when concluding the convention, and also that it has to radically transform the extent of the obligations to be assumed under the convention.
Counsel, in our decision in the Gabčíkovo case, we addressed the question of changed circumstances. And can't it be argued that the kind of circumstances that you're describing are in fact quite similar to the sorts of changes that the court found insufficient in the Gabčíkovo case?
Your Excellencies, our submissions is that the case, if that both cases, even though they have some similarities, the reasons why this court did not find that in the Gabčíkovo case there was a fundamental change cannot be applied to the present case. Now, in the Gabčíkovo case, both Slovakia and Hungary signed the treaty in 1977 to regulate the construction of water dams in both Gabčíkovo and Nagy-Maros, and to regulate also the use of the waters of the Danube rivers along the riparian states. Now, in that case, Your Excellencies, it was a joint project for both parties to the construction of the Gabčíkovo-Nagy-Maros project. In the present case, Your Excellencies, we have a natural resource which belongs to Agnostica, and in 1938, Agnostica decided voluntarily to cede to Reverencia the exploitation of marthite under the assumption that it had an insignificant commercial value. And now, Your Excellencies, after 2011, that marthite has an increased economic value, the circumstances under which the Marthite Convention have fundamentally changed, Your Excellency. Now, the threshold that has been put forward by this court in the same Gabčíkovo decision, specifically in paragraph 104, is that the change in the circumstances must constitute an essential basis for the consent and be closely linked to the object and purpose. Now the respondent, in its written brief, submits that such requisite is not met, and specifically the threshold put by this court in its Capchicovo decision is not met. However, Your Excellency, if one gives a close reading to the preamble of the Maarten Convention, and specifically the construction of the preambulatory language, which can be found in Annex 1 to the compromise, it is clear that there is a link between the object and purpose of the Maarten Convention, contained in letter D of the preamble.
Why doesn't your analysis destroy the doctrine of rebus sic stantibus? If you make a bad deal and you don't foresee enough, you just call it changed circumstances. So nobody gets held to the bargain that they made. So your side just gets wrong.
Your Excellency, it is not our submission that any time a state signs a treaty and makes a bad deal in economic terms can call for the fundamental change of the circumstances.
So what is your test? What is your test?
Your Excellencies, our test is the threshold that has been put forward by this court regarding the objective requisites that have to be met. And we submit that in this case, since the Maarten Convention contained in letter E of the preamble a specific clause which established that both parties were in agreement that Maarten was without significant commercial value, then the parties can claim, that Agnostica can claim that it was an essential basis for the consent when concluding the Maarten Convention. Now, furthermore, Your Excellencies, this court dealt with this matter last year in its whaling in the Antarctica case at paragraph 56, when it analyzed the preambulatory language contained in the International Convention on the Regulation of Whaling to determine if the object and purpose could be found in the preamble itself. Now, we submit, Your Excellencies, in the present case, that the object and purpose is to ensure a reliable supply of marthite for those to whom it holds a cultural significance. However, Your Excellencies, it was a prerequisite for Agnostica's consent when concluding the Marthite Convention, and both parties understood this to be true, that marthite was without significant commercial value. Now, Your Excellencies, the other point that has been contended by the respondent in its written submissions is that the change in the circumstances, specifically regarding the price of marthite, did not radically transform the extent of the obligations to be performed. Now, Agnostica understands that it is a difficult task to determine if the performance of the obligations have changed, since in the present case, the obligations that Agnostica has under the Marthite Convention is a negative obligation to allow RMT to exploit marthite and distribute it along Reverentia and East Agnostica. However, Your Excellencies, we do agree with the respondent in the threshold for this requisite to be met, which was put forward by this court in its 1973 fisheries jurisdiction case in paragraph 63, where it established that a change in the circumstances must radically transform the extent of the obligations to such extent as to render its performance something different from what the parties originally undertaken. Now, we submit, Your Excellencies, that there is a more burdensome obligation for Agnostica, which was the relationship made, for example, by Special Rapporteur on the Law of Treaties, Sir Gerald Fitzmaurice, in its second report, where it did establish that the extent of the obligations could be related to the creation of more burdensome obligations for the party. And we submit, Your Excellencies, that it is more burdensome for Agnostica to allow and consent a state to extract a mineral which is a valuable commodity for Agnostica, especially considering that the applicant is a landlocked country whose livelihood and economic development depends on the exploitation and exportation of its natural resources.
What weight should the court give to an early report of the Special Rapporteur? I think that was nearly the last report he wrote before he became a member of this bench. And then the later rapporteur, Sir Humphrey Waldock, was the one who carried it all on. Just what is the legal weight of that view of Sir Gerald?
Your Excellencies, we do submit that it is persuasive and that it does qualify as a subsidiary source of international law under Article 38(1) letter D, since Sir Gerald Fitzmaurice can be qualified as a highly renowned publicist. And furthermore, this court has previously given weight to the work of the International Law Commission, for example, in its 2007 genocide case. And we
yes, but that's a finalized report, isn't it, that is being used there? That's a quite different document.
Yes.
Sorry, go ahead. Did you want to respond to that?
I can wait for your question, Your Excellency, or respond.
No, finish that and then I'll ask my question.
We do submit, though, Your Excellency, that it is a subsidiary source of international law for the determination of the rule of law.
Thank you.
Counsel, you've answered my earlier question about the relationship between the Vienna Convention as to changed circumstances and customary international law, but you're invoking the change in circumstances as a basis to terminate the treaty. It doesn't appear, however, that Agnostica took the steps that are called for procedurally under the Vienna Convention. So I'd like to understand what your view is on the applicability of that aspect of the Vienna Convention.
Certainly, Your Excellencies. We do submit that Article 65, as this court provided in its Gapchikova-Nagimaros decision at paragraph 109, is reflective of customary international law and not a codification of it. And in that same paragraph, what this court did, was to make reference to its 1980 WHO and Egypt advisory opinion, when it provided, Your Excellency, that states had a duty to negotiate in good faith when terminating a treaty, and thus that the specific time limits considered in Article 65, for example, regarding the 3 months notice, was not necessary under customary international law. Now, if one looks at the fact of the present case, Your Excellencies, according to paragraph 14 of the compromise, Prime Minister Moot issued its first declaration in February 1st of 2012, when it invoked the fundamental change of the circumstances as the grounds for terminating the Martha Convention. Then, 20 days later, in February 21st, Reverentia sovereignly and unfoundly objected to this proposal, Your Excellencies, and it was a blank proposal without offering a counter-proposal for the negotiations of the termination. 2 months later, Your Excellencies, Agnostica terminated the Martha Convention after Reverentia refused to negotiate, and Your Excellencies, thinking that even if this court considers that a deadlock was reached between the parties, there was a right for Agnostica to terminate the Martha Convention, since the substantive requisites for the fundamental change of the circumstances had already been met. Now, Your Excellency,
you say that there was a refusal to negotiate on the respondent's side. I was just looking at the compromise and trying to find that.
Your Excellencies, we submit that in paragraph 15 of the compromise, President Novalu states that there is no reason to terminate the Martha Convention, and he does not give a counter-proposal on Agnostica's previous intention, where Prime Minister Moot of Agnostica, in paragraph 14, attempted to terminate the Martha Convention and also offered Reverentia a reimbursement of the cost of staffing and constructing the facilities, and a formula designed to compensate Reverentia for its losses until the remainder of the convention. Now, we do submit, Your Excellencies, that the negotiation requirement was met in the present case, and thus that Agnostica did have a right to terminate the Martha Convention. However, Your Excellencies, even if this court were to find that a deadlock was reached between the parties, there is no need to give recourse to the other means contained in Article 33 of the United Nations Charter, since, for example, as Special Rapporteur Sir Humphrey Waldock provides, once a deadlock is reached between the parties, it is for the party claiming to terminate the treaty to act in good faith. And it is our contention that Agnostica did act in good faith at all times when terminating the Martha Convention. Now, Your Excellencies, if there are no further questions regarding the termination of the Martha Convention, I will now turn to the fourth and final question presented to the court, which revolves around the unlawful removal of the software from the Martha extraction facilities ordered by Reverentia. Now, Your Excellencies, this issue presents the following two questions. The first of them, Your Excellencies, and in case this court were to find in favor of the applicant regarding the termination of the Martha Convention, concerns the ownership of the software in hands of Agnostica. And
what if instead of removing the software, they had simply sent a computer signal deleting the software?
Your Excellencies, we do believe that that would have been even worse, since we do recognize that by removing the software, Reverentia did have the possibility to put it back again in the facilities, as it actually did according to Clarification 13.
Under my hypothetical, they could put it back tomorrow by a computer signal.
Your Excellencies, that could be a possibility. However, there is not enough proof in the compromise as to whether that could have been done by the respondent. However, in the case at hand, Reverentia physically removed the software, as it is explained in paragraph 17 of the compromise, Your Excellencies. However, our primary contention in this regard is that if this court were to find that the Martha Convention was terminated, Agnostica has ownership over the software, since the software forms part of the facilities according to the language used in the Martha Convention. Now, the Maastricht Convention clearly makes a distinction in Article 1 towards what is going to be a facility which is going to be owned by Agnostica and technology which only has to be provided to Agnostica during the duration of the Maastricht Convention. Now, Your Excellencies, in Article 2 of the Maastricht Convention, it is stated that upon the payment of 100 Swiss francs, Agnostica became an owner of the facilities described in Article 1. However, Your Excellencies, clarification 5 of the compromise provides that the facilities described in Article 1 merely denote the specific geographic location of the facilities, but not certain specific buildings that were bought by the applicant in 1938. Thus, Your Excellencies, we do submit that the applicant in 1938 bought the concept of facilities, and thus everything that was going to be constructed by Reverentia during the duration of the Maastricht Convention, which formed part of the facilities, was going to be owned by Agnostica. Now, we do believe, Your Excellencies, that the software forms part of the facilities if an evolutionary interpretation of treaties is considered. Now, this kind of interpretation has previously...
Why are the facilities the hardware?
Your Excellencies, we do submit, though, however, that due to the importance that the software holds for the exploitation of Marthite, as, for example, is established in paragraph 21 of the compromise, where it is stated that the production went down from 200 or 250 tons per year to only 100 kilograms a day, showed that the software was an inherent and a necessary part for the exploitation process of Marthite. And thus, Your Excellencies, we do submit that since both parties considered generic terms when concluding the Maastricht Convention, in this case facilities and technology, they intended for those terms to have an evolving meaning. Now, even though this court should consider the ordinary meaning of the terms as established in Article 31 of the Vienna Convention, and by establishing the ordinary meaning of the terms, it could seem that the software was part of the technology, Your Excellencies, this court should also consider the technical language in the context of mining, which is what the Maastricht Convention is about, Your Excellencies. And for example, national legislation, such as, for example, in Papua New Guinea, have established that a software forms part of the infrastructure in the mining process. Now, furthermore, Your Excellencies, the WTO in its 1996 Council of Ministers did provide, Your Excellencies, that a software was the physical backbone which allowed a facility to function. And we do submit in this case that the software created by Reverentia forms part of the facilities, and thus it is owned by the applicant. And by removing it, Your Excellencies, Reverentia has seized and violated international law by attempting against Agnostica's property. Now, Your Excellencies, finally making...
Sorry, could I just ask a question which I should have checked myself about the arithmetic? You mentioned that the annual take was 200 tonnes a year, and it had fallen to 100 kilograms a day. What sort of a fall is that? I should have, as I say, I should have done the arithmetic myself, but can you tell me?
Your Excellency, I apologize. I do not have the exact numbers with me to show the percentage of the fall.
That's fine, thank you.
Excuse me, Your Excellency. Now, if it pleases the court, I will turn to the last issue presented before the court, which responds to Reverentia's contention that the removal of the software constituted a lawful countermeasure. Now, Your Excellencies, this submission is only in the case this court were to find that the Maastricht Convention continued to be in effect after April 2nd of 2012, excuse me. And thus, Your Excellency, the respondent has contended that a countermeasure was exercised in the removal of the software. Now, we submit that the legislation applicable in the present case is the one contained in the Articles on State Responsibility, specifically in Articles 49 to 52, which regulates the exercise of countermeasures. And it is our submission that the respondent did not comply with the proportionality requirement laid down in Article 51 of the Articles on State Responsibility. Now, such article provides that the implementation of a countermeasure has been commensurate with the injury suffered and taking into account the rights in question. Now, the Reverentia has contended in the present case that the lease of the facilities to Baxter was in violation of the Maastricht Convention. Now, we submit in the contrary, but if this court were to find that the lease of the facilities to Baxter violated the Maastricht Convention, the only injury that Reverentia suffered by that was an economic injury in terms of the money that they invested in the construction of the mining facilities in East Agnostica. On the other hand, Your Excellency, when Reverentia removed the software from the facilities, Agnostica was no longer able to exploit its natural resources, and Reverencia did not comply with ensuring a reliable supply of marthite to those traditional practitioners, especially considering.
Counsel, how are we supposed to conduct this proportionality analysis? It seems to me that there's a considerable indication, in fact, that it was possible to produce martite after the software was removed, albeit at a lower level.
Your Excellency, even though it was still possible to extract a little bit of marthite, we do consider that the fall was of significant amount after the software was removed, and thus what cannot compare the injury that was suffered by Reverencia, which was only an economic injury in terms of the investment, and on the other hand, Agnostica could not freely exploit its sovereign natural resources. And on the other hand, Your Excellencies, if one considers the rights in question in the present case, Your Excellencies, I've realized that I've run out of time.
Could I ask just the last question? When
Certainly.
Sony's servers and movies were disrupted by the DPRK, President Obama called it cyber vandalism. Could you just say this is cyber vandalism?
Your Excellency, I am not sure what the definition of cyber vandalism would be in the
Neither
present
am
case.
I, but that's why I want to call it that.
Your Excellency, we would not dare to call this cyber vandalism, but we do not think that the requirements for a countermeasure to be met would be valid in the present case, and thus the removal of the software should be rendered as unlawful by this court. With this, Your Excellencies, I conclude the applicant's third and fourth submission. Thank you.
Thank you, Mr. Salas, and thanks to counsel for the applicant. And now, counsel for the respondent. If we could hear from you, please.
Mr. President, Your Excellencies, my name is Alice Joe, and I appear on behalf of the respondent, the State of Reverencia, with my co-agent, Sarah Bradbury.
Thank you, Ms. Joan.
I will speak for 22 minutes on the referendum and secession of East Agnostica. My co-agent will speak for a further 22 minutes on the Marthite Convention and the removal of software, and we reserve 1 minute for Sir rebuttal.
Yes, thank you.
In late 2012, the Agnorevs protested the restriction of their ancestral cultural practices. Agnostica's response was to deploy the national police and the military. The critical question for this court is whether Reverencia's response in offering these people aid and support and allowing them to integrate was consistent with international law. In response to the submissions made by the applicant, I have two submissions. First, that Reverencia's support for the referendum was lawful, and secondly, that the secession and integration of East Agnostica into Reverencia was consistent with international law. Turning to the first submission regarding the referendum, the applicant has relied upon 3 grounds. First, a breach of the principle of non-intervention. Secondly, a breach of territorial integrity. And thirdly, a breach of the United Nations Charter generally. In relation to the first submission regarding non-intervention, we accept the law as has been put by the applicant, that what is critical is a method of coercion, as was identified by this court in its 1986 Nicaragua decision. And thus the critical contention between the two parties is whether Reverencia's conduct involved a method of coercion such as to breach that principle. To this end, the applicants have relied upon the 1981 declaration, which states that all action in support of a secessionist entity would be a breach of the principle. However, this declaration is not custom and was rejected by 22 states, including that of the US, the UK, France, and Australia, on the very basis that that all support for secessionist entities does not satisfy the necessary element of coercion. And thus turning...
Well, we understand your position, which is that when you divide and conquer as you do, non-coercive protest, non-coercive resolution, non-coercive placement of troops, you end up with a lot of activity that yields this result. Can't we just say that when you put it all together, it's an intervention?
No, Your Excellency, and that is consistent with the practice of this court in having regard to actions that amount to intervention. In the 1986 Nicaragua decision, this court had regard to the elements of arming, funding, and organising and instigating the Contras as individual acts. But even taking the acts cumulatively, putting the argument of the applicant at its highest, we submit that it did not amount to a method of coercion, such as to breach the principle. To this end, the applicants have relied on 3 acts. First, President Nuvales's speech at paragraph 34 of the compromise. Secondly, the parliamentary resolution at paragraph 35. And thirdly, the movement of troops at paragraph 37.
Counsel, before you get to the facts, if I can just ask you to return to the statement about the law that you made. You have said that the Friendly Relations Declaration is not customary international law. Aren't you therefore asking this court to reverse what we said quite recently in the Kosovo opinion, where we said that the declaration reflects customary international law?
Your Excellency, we accept that the 1970 Friendly Relations Declaration is custom, and to the extent that in that declaration there is regard to support for subversive groups who seek the violent overthrow of a government, we submit that the threshold in order to make out coercion is high. What we contest is whether the 1981 declaration regarding the intervention and inadmissibility in the domestic affairs of states is custom. And on that basis, it is not all action which amounts to coercive action. Here, having regard to the speech, political representations are permissible under international law, and we would turn, for example, to the 1967 speech of President Charles de Gaulle, where in similar terms he supported the secessionist movement in Quebec. The only country that came out in condemnation of this was Canada, the parent state, and they stated that it was merely unacceptable, but not unlawful. To the extent that the applicant...
They wouldn't have said but not unlawful, would they?
No, Mr.
Yeah,
President.
that was your gloss on what Canada said.
Yes, Mr. President, to the extent that while they did not say it was unlawful, at best they said that it was unacceptable.
Yes, yes.
But can't we just break through the fictions here? International law is flexible to accept the notion of creeping expropriation as expropriation. Why isn't this just creeping intervention that had the exact same outcome as a direct intervention done in one big step? Why should we allow be done in a bunch of little steps that you could not do in one big step?
Your Excellency, we would contest that this is a case of intervention being done in multiple little steps. The fact that the speech only made a comment on the circumstances in reverentia, in agnostica, and to the extent that the applicants sought to distinguish this because of the statements that they would act with all within their power, as is evidenced, for example, from the statements by Angela Merkel's governing partners, the Social Democrats, who similarly used such phrases in March of last year. Such comments do not cross the threshold in order to amount to intervention. However, even coupled with the resolution, we submit that this does not cross the threshold. The resolution, as relied upon by the applicant, was merely permissive in that it only authorised President Nuvales to act, and moreover, it was conditional. The applicants have sought to rely on the phrase "all necessary measures" as indicating a willingness to intervene by all means. However, that is in the context of all necessary measures to ensure the integrity and security of an East agnostican state, and thus that is only activated when East agnostica is a state, and on that basis would not amount to intervention in the affairs of agnostica. In respect of the movement of troops, we submit that even taking the speech, the resolution, and in addition now, the movement of troops at paragraph 37 of the compromise, that action was not coercive, and that is made clear by President Nuvales's diplomatic note which accompanied the movement of troops. That being that the purpose of those troops was to offer aid to any fleeing Agnorevs and out of concern for violence. As has been the practice of this court, great weight should be given to statements made by heads of state. And as this court did in the 1974 nuclear test decision, the statements by France were taken with the confidence and trust that is necessary for international relations. But moreover, we submit that the concerns within the note were legitimate. In light of the events that had occurred at paragraph 29 of the compromise, where the police had been deployed in similar circumstances concerning Agnerev freedom, that resulted in 60 deaths. In light of the fact that independence referenda, as we know, for example, looking to the 1999 East Timorese independence referendum, can result in violence and can result in a spill of refugees. It was a legitimate concern of President Nuvalis and one that should not be called into question.
But isn't the whole point that the referendum, the claim is that the referendum was coerced and that the troops were there in case it went the wrong way?
No, Your Excellency. We reject the submission that the placement of the troops was for the purpose of intimidating Agnostica to let that referendum go ahead. And that, as we have submitted, is made clear by the note. The purpose was to offer aid to any fleeing Agnerevs and to ensure, out of concern, for violence spilling over.
Counsel, isn't it a concern for this court that perhaps what's going on with the diplomatic note is that Professor Nuvalis has actually just been very well advised by his lawyers to insert these reasons into the note while in fact having a different motivation?
No, Your Excellency, and that is first, because there is a presumption of good faith with respect to state actions, as was recognised by this court in the 2009 dispute regarding navigational rights, and that has not been rebutted on the facts. Even taking the three actions that the applicant relies on cumulatively, we submit that the speech and the resolution before this don't undermine the credibility of President Nuvalis' note. The phrases that reverentia would do all within its power, or that it would use all necessary measures, are vague and ought to be interpreted consistent with international law. Texts emanating from a government are to be given this treatment, as was stated by this court in its 1957 right of passage decision. The second ground that the applicant...
If the Reverentian troops had crossed the border, would you concede it was an intervention?
Yes, Your Excellency. In those circumstances, we submit that if the purpose was to coerce Agnostica to allow the referendum to go ahead by the entry of troops.
Well, if that's the purpose, can't we decide that even if they never crossed?
Yes, Your Excellency.
So we could decide that.
Yes, Your Excellency. However, that is diffused by the note. The second ground that the applicants rely on is a breach of the principle of territorial integrity. However, that is not an independent wrong, as distinct from their reliance upon the principle of non-intervention. And as this court recognised at paragraph 251 of the 1986 Nicaragua decision, the principles of territorial integrity and non-intervention overlap. And to the extent that if this court was against us on our first submission regarding intervention, then we accept that there has been a breach of territorial integrity, but that it is not one that is distinct from that first ground upon which the applicant relies. To address the third ground upon which the applicant relies, and that is a breach of the United Nations Charter generally. In particular, the applicant has pointed to the promotion of international peace and security as contained within Article 1, Paragraph 1 of the Charter. However, to the extent that reverentious support was in support of the self-determination of a people whose self-determination has been violated, and as recognised in the 1970 Friendly Relations Declaration, the support of self-determination of the peoples is integral to supporting international peace and security. We submit that that ground has not been violated.
We understand your position, but if we found, contrary to your argument, that all this amounted to a threat of use of force, would you concede that that's a violation of Article 2.4? Or would you argue that threat is no longer part of the law of the use of force under Article 2.4?
We accept that threat is within Article 2, Paragraph 4. However, we submit that a threat has not been made out here. First, we note that the applicants have not contested whether there is a threat of force. But secondly, we submit that in order for there to be a threat of force, as was stated by this court in its 1949 Corfu Channel decision, an essential element is political pressure. And for the same reasons that Reverentia did not coerce Agnostica by virtue of President Novalis' note and the surrounding circumstances with the movement of troops. We submit that there was no political pressure exerted on Agnostica.
Isn't pressure in the eyes of the beholder? If I see a couple hundred troops on the border and I feel pressure and I go to the polls, isn't that pressure?
No, Your Excellency, and that is because the test is one that is objective. And that was the approach of this court in its 1986 Nicaragua decision, where it looked to the surrounding circumstances, but not the subjective feelings of either state. Turning to the second submission then, regarding the secession and integration of East Agnostica. Contrary to the submissions of the applicant, that Reverentia's movement of troops into East Agnostica at paragraph 41 of the compromise amounted to an illegal annexation, we submit that East Agnostica had formed a state that was capable of integrating. On the question of whether the secession was consistent with international law, the applicants have stated that there must be a right in order to secede. However, secession is neither legal nor illegal under international law, but a legally neutral act. And therefore, this court is not concerned with the act of secession, but rather with its legal consequences, and that is whether a state was created. This is consistent, for example, with the approach of the Badinter Commission in addressing the breakup of Yugoslavia, where the Badinter Commission did not have regard to a question of rights, but was looking at elements of statehood and the question of effective dissolution, and that is whether the federal organs had ceased to function as federal entities. To the extent that the applicants place great weight on the principle of territorial integrity, as Your Excellency noted in a question to the applicant, territorial integrity is a principle that is confined between states, and that was recognised by this court in its 2010 Kosovo opinion. And to that extent, we submit that given that there is no prohibition on the ability of a secessionist entity to separate from a state, a right does not need to be made out.
Counsel, what is the standard that we should apply in determining whether a new state has emerged here?
This court is to have regard to the criteria for statehood contained under the 1933 Montevideo Convention, which both parties are states parties to, as we know, at paragraph 44 of the compromise. Turning to consider whether those elements have been made out. First, there is a permanent population, as we know that the Agnorevs have been there since at least the 18th century, at paragraphs 1 and 4 of the compromise. With respect to the question of a defined territory, the territory of East Agnostica was the former province of East Agnostica, and it is immaterial that it is being contested by Agnostica, as was stated in the Deutsche Kontinentalgasgesellschaft decision. And with respect to the capacity to enter into foreign relations, this is evidenced by the negotiation and conclusion of the integration agreement between East Agnostica and Reverentia. Thus, perhaps the most contentious element between the two parties is whether the question of effective government is made out. On this element, first, pre-existing provincial governments are presumed to be more effective, and that their functionality is to continue following dissolution. And that was the case with respect to the breakup of former Yugoslavia and recognised by the Badinter Commission. In light of the fact that we know that the Agnorev provincial parliament was able to organise a referendum despite opposition by Agnostica, we submit that this is evidence of their effective governance before and that which would carry on as they became a state.
And Counsel, you've pointed out that the two states are parties to the Montevideo Convention. What kind of weight, if any, should we give to the patterns of recognition of the new state here?
Recognition is merely declaratory, pursuant to Article 3 of the Montevideo Convention. However, it is strong evidence of statehood, as was recognised by the Badinter Commission in Opinion 8. And to that extent, given that 30 states have recognised the changed borders and thus, implicitly, the statehood of East Agnostica and its ability to integrate as a state, we submit that that is evidence of the criteria of statehood being made out.
Under your test, why isn't Kurdistan a state right now?
Kurdistan is not a state because it would violate the principle of uti possidetis, and that operates to ensure that the internal boundaries of a state become the new international frontiers and can only be modified by consent. And that was stated by the Badinter Commission in Opinion 3. Here, that is not an issue. In light of the fact that there is a boundary between West Agnostica and East Agnostica, and that upon secession, East Agnostica's boundary became the new international frontier, Your Excellencies, that is consistent with the principle of uti possidetis.
Does that principle or practice apply, going back to the Kurdistan example, for instance, does that apply in the Middle East or does it apply in our geographic area? Because it's been applied in Latin America and in Africa, but is it a completely general proposition or general principle?
It is, Mr. President, and we accept that in circumstances in Africa, for example, that it was on the basis of consent that the principle was applied. But to the extent that we note, for example, in former Yugoslavia, the internal boundaries of the former Yugoslav states became the new international frontiers, that understanding of uti possidetis with respect to federal entities is relevant here. Taking the submission of the applicant at its highest, however, and that is that a right does need to be made out, we submit that this is supported in custom.
But if there was a piece of East Agnostica that had a permanent population-defined territory, capacity to enter into foreign agreements and effective government, could they go back? Would you say, let it go?
Your Excellency, given that East Agnostica signed the integration agreement and integrated into Reverentia, we submit that the new boundary between Reverentia and East Agnostica is now no longer an internal boundary that can become an international boundary. And on that basis, the court should not order retrocession, in addition to the fact that it would be against the will of the Agnorevs. To briefly address the strongest argument put against us, and that is that a right does need to be made out at custom, we submit that this can be a right to secede on the basis of self-determination can be made out. We would have regard to the 1970 Friendly Relations Declaration, which is accepted as custom, which states that a territorial integrity of a state can be called into question when the right of peoples to self-determination has been denied, and moreover would point to the secessions of Bangladesh in 1971, and if this court were not to accept secessions as a question of fact, the breakup of Yugoslavia, as is contained within the declarations of independence, statements pursuing the right of self-determination. On that basis, we submit that the applicant erred in stating that no states have been created without the consent of the parent state. The threshold in order to make this out has been met, given the systemic discrimination that occurred with respect to the Agnorevs, having regard to the passing of the Maathai Control Act and their political impotency, unable to de-escalate matters within their own province, and the fact that although cultural powers had ostensibly been devolved, the Maathai Control Act was nonetheless passed. On this basis, the right of self-determination had been sufficiently violated to grant a right to secede. May it please the...
Sorry, what authority is that to support the right of remedial secession? The court heard a great deal about it in the Kosovo case, but stood back. But please continue.
Thank you, Mr. President. The right can be found in custom, and that is on the state practice of Bangladesh and the breakup of Yugoslavia, as well as its implicit recognition in the 1970 Friendly Relations Declaration. But it has also been recognised in judicial decisions. Judge Jessup had regard to the potential of such a right existing in the 2010 Kosovo opinion. It was recognised by the African Commission on Human and People's Rights in the Katanga case and the Cameroon case, and moreover was recognised in the 1921 Ireland Islands decision of the Commission of Rapporteurs. And on that basis, such a right does exist. May it please the Court, I now defer to my co-agent.
Thank you, Ms. Yu. And now, Ms. Bradbury, please. Yes, Ms. Bradbury.
Mr. President, Your Excellencies, in response to the second agent for the applicant, I have two submissions. First, that Agnostica did not validly terminate the Marthite Convention on the 2nd of April 2012. And secondly, that Reverentia's removal of software from the Marthite mining facilities was consistent with international law. Turning first to the termination of the Marthite Convention, and it was put by the applicant that this was substantively valid on the basis that a fundamental change of circumstances had occurred and that Agnostica had complied with the procedural requirements for termination. I will address each of these submissions in turn. First, on the question of rebus substantivus. We accept the statement of law that was made by the applicant, and we also accept the characterisation of the relevant change in this case, being the newfound medical use of marthite and the corresponding increase in its commercial value. For the purpose of oral argument, I will only contest two elements of rebus substantivus, that being first, the change must have been unforeseen, and secondly, that its effect must be to radically alter the obligations owed by the parties. And as this is a cumulative test, it is sufficient for this court to accept either one of these submissions. Turning first to the question of whether the change was unforeseen, and it was put by the applicant that the presence of paragraph E of the preamble to the convention, stating the parties entered into the Marthite Convention recognising this was without significant commercial value outside its traditional uses, demonstrates that it was unforeseen that a change would materialise. However, Your Excellencies, taking guidance from the approach of this court in the 1997 Gabčíkovo-Najmaroš case at paragraph 104, the court must look to the text of the agreement and ascertain whether any provisions indicate that the parties contemplated the change which occurred. And here, we rely on Article 4, paragraph D of the Marthite Convention, which, Your Excellencies, is given further content in paragraph 2 of the corrections to the compromise. That paragraph allows for Reverentia to sell marthite to third parties in circumstances where the supply of marthite in a calendar year meets traditional demand and then exceeds it by 25%. And in those circumstances, Reverentia is able to sell marthite to third parties without discrimination as to identity of purchaser, intended use, or critically, Your Excellencies, price. The parties entering into this agreement specifically included a provision allowing Reverentia to sell marthite at a price higher than that for traditional users, and accordingly we submit that it cannot be said that this was a completely unforeseen change, that the price of marthite in an external market increased. Turning, Your Excellencies, to our submission that is further or in the alternative to the question of foreseeability, we submit that Agnostica's obligations under the Marthite Convention have not been radically altered as an effect of this change. We accept the statement of the applicant that the relevant test is whether the burden of performing that obligation has been rendered something essentially different, and accordingly this court need not look to whether the form of that obligation has changed, pursuant to the decision of this court in the 1973 Fisheries Jurisdiction case at paragraph 32. Here, we submit that Agnostica's obligations have not changed in any appreciable way. Agnostica is still receiving the same 10% royalty which it envisaged receiving under Article 3 of the Marthite Convention, and this must be considered in light of the fact that under Article 1, it is Reverentia who incurs all operational expenses and all distribution expenses. The applicant's submission at its highest pointed to the changed fiscal consequences of performance to substantiate a change in burden. However, as stated by this court,
In the 1997 Gabčíkovo-Nadžimář case, at paragraph 104, a mere change in the profitability of a venture between two states is not sufficient to demonstrate a fundamental change.
Would you concede there's any point where a change of degree is so radical it becomes a change of kind? So if the price just dramatically shot up, or the terms dramatically changed, because it would just become a change of kind, and that's fundamental change of circumstances.
Yes, Your Excellency, and that is where this doctrine can be distinguished from, for example, impossibility of performance. That is not the threshold, as has been stated by this court in fisheries jurisdiction and the Gabčíkovo case. However, here, the relevant change is not as severe as has been characterised by the applicant in their written memorial. The market price of marfite has not been increased to a permanent tenfold amount, but rather, in response to the initial findings that marfite could be used to treat autoimmune disorders in children, at paragraph 12 of the compromise, the price set by that initial boom in demand was up to 10 times. However, we know from paragraph 11 of the clarifications to the compromise that in the calendar year of 2012, that price had normalised and was now only being sold for approximately double the price accepted by the convention. To that extent, we submit this was not so radical as to completely change the obligations owed by the parties. We submit that this court should follow its jurisprudence in the Gabčíkovo-Nadžimář case and not accept this mere decrease in the profitability of a venture as to give rise to the quite extreme act of unilaterally terminating an agreement that was entered into by consent between two states.
And counsel, so if the court finds that there was a fundamental change of circumstances within the meaning of Article 62 of the Vienna Convention, is that the end of this argument for you? Does that mean that we should find that the treaty was lawfully terminated?
No, it is not, Your Excellency. And that is because even if this court is against us and finds that a fundamental change is present, that only gives rise to Agnostica's right to terminate. And to exercise that right, as identified by Your Excellencies in questions to the applicant, specific procedural criteria must be satisfied. This takes me to my second submission. We agree with the statement of the applicant that the relevant law applicable in this case is not the stringent requirements of Article 65 of the 1969 Vienna Convention on the Law of Treaties, but is rather the customary requirement to give notice and to negotiate in good faith, as stated by this court in its 1980 advisory opinion on the dispute between the World Health Organization and Egypt at paragraph 85. And here, we disagree with the statement of the applicant that Agnostica negotiated in good faith. Your Excellencies, this court, in its 2011 preliminary objections decision on the application of the Convention on Racial Discrimination, provided a useful definition at paragraph 85 of what it is entailing in engaging in good faith negotiations. And that is, to quote, a genuine attempt by one of the disputing parties to engage in discussions with the other party with a view to resolving that dispute. We submit that this cannot be made out on the facts. At paragraph 14 of the compromise, Agnostican Prime Minister Moritz gave notice to Reverentia that Agnostica sought to terminate the Marfite Convention by mutual consent. And in response to this, the Reverentian President outlined Reverentia's position, that Reverentia was not interested in terminating this agreement, that had served the people of Reverentia so well for 74 years.
Aren't you in a funny position to be arguing a genuine commitment to engage when the questions we've asked your colleague are all about partial measures that lead to a kind of coercion? I mean, did you engage them forthrightly on the question of secession?
Your Excellency, could you please repeat the question?
Yes, you are saying now there should be a genuine engagement on this question, and I'm saying that your colleague's position has been that a series of unilateral steps which never amount to coercion just never becomes illegal. But it seems to me that you could equally ask your colleague, why didn't you engage in the same way, forthrightly? negotiate?
Your Excellency, we submit that in the circumstances regarding the submissions made by my co-agent, there were specific circumstances that led to a situation whereby Reverentia's actions in condemning the violence that had been occurring in East Agnostica is separate to the placement of the military troops at the border of Reverentia to protect any overflow of violence, and so no such requirement to negotiate with Agnostica in good faith arises, because there was not that mandatory obligation on both parties. Here, however, it is a requirement for the validity of any treaty termination that the parties do engage in such negotiations. We submit that one offer to terminate by mutual consent, met by a response that termination was not Reverentia's favoured outcome, does not constitute negotiations. And we disagree with the characterisation put by the applicant that there was a deadlock in these negotiations. Because while we accept that that does give rise to a right to cease negotiating perhaps earlier than what would have been, consistent with the decision of this court, or its advisory opinion rather, in the 1971 Namibia case, whereby it was stated at paragraph 85, the parties may end negotiations where such an early deadlock is reached. In that case, negotiations had occurred for 13 years. Several General Assembly resolutions and Security Council resolutions had requested that South Africa either allow for the United Nations to supervise the administration of Namibia, or to suggest to South Africa that it allow Namibia to enter into trusteeship. And here, we submit that this cannot be compared to those circumstances of deadlock where South Africa refused to negotiate, whereby Reverentia here only suggested that termination was not the desirable outcome. To that extent, Agnostica did not comply with its procedural requirements. Your Excellencies, I will turn now to the final issue in these proceedings, and that concerns Reverentia's removal of software from the Marthite mining facilities. And in relation to this submission, it was put by the applicant two submissions in the alternative. First, regarding whether, if the Marthite Convention was validly terminated, the property was lawfully removed, and secondly, whether, if the treaty was still in effect, the removal of software was a violation of that obligation. I will address each of these submissions in turn. First, on the question of ownership of property. Your Excellencies, we submit that if the Marthite Convention was validly terminated, that Reverentia's removal of software was the lawful removal of property which it owned. To counter this submission, it was put by the applicant that if this court is to interpret the Marthite Convention, technology in Article 1 formed part of the transfer of facilities in Article 2. And while we accept that the word technology should attract that evolutionary interpretation and thereby include the software at the heart of these proceedings, we disagree that technology formed part of that original transfer.
If Reverentia had destroyed the software so it could never be used by anybody else, would that be disproportionate?
Your Excellency, the question of proportionality goes to our second submission regarding countermeasures. And in those circumstances, then yes, such a method perhaps would be disproportionate. However, here, if the act was merely destroying that property, on the question of property ownership, we submit that this would not be the concern for international law because Reverentia would be destroying property which it owned. And critically, Your Excellencies, we put this submission before the court on the basis that pursuant to this court's decision in the 1994 territorial dispute case between Libya and Chad, at paragraph 92, primacy must be given to the text of the treaty. Here, if I may direct Your Excellencies to Article 1 of the Marthite Convention, technology and facilities are clear and distinct concepts. Facilities is part of the first and executed obligation to construct those facilities, and this is separated by a comma and the disjunctive use of the word and from the ongoing obligations.
Aren't the facilities worthless without the software or useless?
No, they are not, Your Excellency, because those facilities are still valuable buildings on territory which is the only known deposits of marthite in the world, pursuant to paragraph 9 of the Compromis. Here we submit that, and to answer the crux of Your Excellency's question and the submission put by the applicant, that the technology was not a necessary part of those facilities to the extent of it becoming part of the facilities. And that is because we know from
But wouldn't you concede that if Reverentia had actually destroyed part of a building, it would have had a less dramatic effect than removing the software?
Yes, Your Excellency, depending on what part of the building that was. Your Excellencies, just briefly, to assist the court with the arithmetic regarding the productivity of the marthite mining facilities following the removal of software, we know from paragraph 21 of the Compromis that 100 kilograms of marthite were still being extracted daily without the benefit of Reverentia's software. And this should be compared to the 500 kilograms daily that was being extracted beforehand, this being the calculation of the figures in the Compromis. And Your Excellencies, while we accept that this did reduce the capacity of the marthite mining facilities, this court need not adopt an interpretation that gives maximum effect and maximum efficiency to the facilities which were transferred, but should rather give effect to the expressed intention of the parties in this agreement. And this interpretation is further supported, Your Excellencies, by the use of the words facilities and technology in Article 1, but only the use of the word facilities in Article 2. And we submit that this supports an interpretation that technology was not to form part of those facilities, because if that were to be otherwise, that word would
But my
also...
prior question suggested that your technical parsing of facilities versus software misses the real object and purpose, which is to keep this operation running. And if you remove the software and the whole place shuts down, you've destroyed the object and purpose of the agreement.
No, Your Excellency, and that is because the object and purpose of this agreement was not that Agnostica receive a fully functioning marthite mining facility, but rather that Agnostica receive the buildings, the marthite mining facilities, mining support facilities, and that Reverentia agree to a period of 99 years to maintain, equip, and operate those facilities with its engineers and its technology. And Your Excellencies, because technology in a 99-year agreement is inherently something which will be removed and replaced and updated, we submit that it would be an arbitrary interpretation for this court to adopt that every piece of technology installed, every new version of the software put on the operating systems would be the property of Agnostica, because then its removal would constantly be infringing Agnostica's property rights. Your Excellencies, turning to the alternative submission, and that is that if this agreement was still in effect, which is our primary submission, on the date that the software was removed, we submit that the wrongfulness of its now failure to comply with its Article 1 obligations to provide that technology is precluded because this act was a valid countermeasure. Your Excellencies, a countermeasure is an act which would otherwise be unlawful but for specific justifying circumstances. And here, the only element of a countermeasure which is being contested by the applicant in oral argument is the requirement that that countermeasure be a proportional response to the initial wrongful act. Your Excellencies, proportionality is assessed by examining the harms caused by the initial wrongful act and the countermeasure, and also the rights that were involved during the taking of each act. To examine the original wrongful act, which we complain of is the wrongful termination of the Marthite Convention and the entry into the lease with Baxter, we contest the statement of the applicant that the only harm that was caused was economic. And that is because, as was stated by the applicant, the object and purpose of this agreement was to ensure a reliable supply of marthite to its traditional users. And it was traditionally used as a key ingredient in Reverentian traditional medicine.
Counsel, are you taking the position that the provisions that were developed by the International Law Commission on countermeasures should be treated by this court as customary international law in all respects?
No, Your Excellency. However, as stated by this court in the 1997 Gabčíkovo-Nadžimaroš case, Articles 49 to 52 concerning countermeasures are a codification of custom. That was stated at paragraph 84. Your Excellencies, in response to that initial wrongful act, whereby Agnostica entered into the lease with Baxter, which we know from paragraph 11 of the compromise made no guarantee of supply of marphite to any traditional users, in light of that, the cultural and the economic harms caused, the temporary and easily reversible act of removing software from computers, accompanied by an immediate promise in paragraph 17 and 18 of the compromise to reinstall that software upon Agnostica's compliance with its obligations under the treaty and its invitation for the reverential engineers to return, was a proportional measure. And Your Excellencies, while we accept that the effect of this countermeasure was to reduce the production of marphite, and it therefore may be argued that it too had the same cultural harm, we know from the 1978 arbitration on the Air Services Agreement between France and the United States that for a countermeasure to be disproportionate, there needs to be a disparity.
Aren't you asking us to endorse a rule in an emerging era of cyberspace where countries can electronically yank their software and coerce results with it? And once we state a rule like that, it has huge implications.
It would, Your Excellency, and that is why we are not requesting such a decision made by this court. The compromise has been drafted in a difficult way, and for that we apologise, Your Excellencies. However, the removal of software is always referred to as being taken, seized, or physically removed. And to that extent, we submit that this is not a cyber attack, but rather the only reasonable inference available on the compromise to satisfy the test stated by this court, the 1949 Corfu Channel case, is that it was a disk or a USB device on which that software was removed. Important because of its
Are you
content.
seriously arguing that that is the basis on which we ought to rule, given that very soon you could wipe a USB blank without even taking it or destroy its capacity to function?
Mr. President, I note my time has expired. May I have 1 minute to answer His Excellency's question?
No, please.
Thank you, Mr. President.
Thank you, Counsel, and thank you to Counsel for the...
Oh, she was going to...
Oh, sorry, yes, answer. I thought you were indicating you weren't going to answer, but please do that.
Thank you, Your Excellency. To answer Your Excellency's question, no, we do not submit that this will set a dangerous precedent in international law, and that's because our primary submission is that here, the question which the court is asked to adjudge is whether the removal of software in these specific circumstances with a promise to reinstall it on assumption of Agnostica's obligations was proportional to the economic and the cultural harm suffered by Reverentia. Those are the submissions of the respondent.
Thank you.
May
Thank
it
you.
please
Now
the
that
court.
I've realised what the arrangement was. Thank you. And in rebuttal, is it Ms. Zavala? I think you reserved 2 minutes. Is that right?
Yes. Mr. President, Your Excellencies, 2 points on rebuttal. First, we submit that the respondent cannot allege that the removal of the software was a lawful countermeasure, since none of the copulative or cumulative requisites for it to apply were present. We submit that the procedural requisite contained in Article 52 on the Articles on State Responsibility, which was recognized in paragraph 83 of the Gabčíkovo-Nadžimaroš project case as customary international law, was not fulfilled. What is required is to call on the other state to cease the wrongful act and further to notify the other party, and we have no evidence in the compromise in such regard, and the respondent cannot allege that this was an urgent matter, since the Baxter engineers arrived a month later, the convention was terminated, and because their reverential engineers were in place. And finally, informer would not render this measure ineffective, since, as we see in the compromise, Agnostica was not able to duplicate the measure, and thus they were required to comply with this. Countermeasures have cumulative and restrictive requisites for the maintenance of peace in the relations between states, as is the second point that we would like to raise. The main point raised in relation to secession is that this is a matter of fact, and that thus complying with the Montevideo Convention criteria would be enough. We contend this on 2 points. First, effectiveness is not enough if we see, for example, the case of South Ossetia, Abkhazia, the northern Cyprus area occupied of Turkish-occupied area, Somaliland, or other cases which could have met this criteria, but who have failed to integrate the international community. Furthermore, if we see relevant jurisprudence as cited by the respondent in the Alien Island case, the Canadian Supreme Court's decision, the African Commission in its Katanga and its Cameroon case, and further paragraph 83 of the Kosovo advisory opinion, where it refers to secession as a right to separate from a state, would be in our favor. Your Excellencies, deciding in the contrary to the applicant in this matter would force states to act forcibly in future secessionist conflicts, because submitting this issue in good faith would not suffice. Thank you very much.
Thank you, Mr. Vallis. And for the respondent, Ms. Yu.
Mr. President, Your Excellencies, 2 points in Sir rebuttal. First, on countermeasures. A countermeasure is urgent if it is necessary to preserve the state's rights. Here, the countermeasure that was taken was urgent, given that the entry into the Baxter lease was announced simultaneously, as we know, at paragraph 16 of the compromise. Secondly, on secession. Effectiveness is sufficient, and that was recognised by the Supreme Court of Canada in the 1998 decision regarding Quebec. The examples that the applicant has relied upon, in those cases, statehood has been obviated by the intervention of a third state. Turning to the example of South Ossetia, for example, that of the case of Russia, and with respect to the Turkish Republic of Northern Cyprus, Turkish intervention. May it please the Court.
Thank you very much. Well, I'm sure that we would, all three of us, thank Council very much for their excellent submissions. We now have to go away and deliberate, not on the substance, which would be far too hard, at least for me at this stage, but in terms of the excellent presentations that both of you have presented, and try to assess, which is always very difficult. It sort of compares with the difficulty of assessing the substance of this case. We have to assess which we think is the better team and which is the best oralist. So we'll take a little time to do that, not as long as the International Court regularly takes. One recent case we took more than a year. Usually it's more like 6 months, or I should say they took nearly a year, except that I was one of them, so I'm part of that pattern. So we will go away, and in the meantime you can relax and talk among yourselves, and we will return once we've met. Well, as I said earlier, it was a formidable performance by both sides. It was in many ways a great change, and I should make an evaluation, I suppose, in some ways, a great change from what I've been used to over the... right. Of what I've been used to, and Judge Donoghue's shared a good part of this time over the last 9 years, because if any of you have ever been to The Hague or watched the court on its televised feeds and so on, you would know that the court is a pretty passive body. I pleaded before it a few times, and it was really very hard to know what those 15 old men, as they were way back then, were really thinking, or how they were reacting. And so it's great to be back in a courtroom where, as was my earlier judging life, where there is the interaction, and it's the kind of interaction that works as well, I must say, within judges' chambers when I'm being challenged by my young assistants, by the clerks and trainees and so on who work within the court system. So excellent performance and fantastic on the facts, on the law. We're all mightily impressed by this immediate reaction in terms of particular paragraphs of particular decisions. In some cases of ones that I was involved in and I didn't quite remember in quite those terms, but I'm sure you were doing it accurately. And in terms of Council's performance too, you were excellent in keeping eye contact. It's really distressing being a judge if all you can see is the top of somebody's head as they go boringly through a text. You want to be able to see how they're really reacting, and Council need to see how the judges are reacting as well. At least in this case, you just had 3 of us to look at. My experience of trying to look at 15 or 16 or 17, it is quite a challenge in that courtroom. Excellent as well in responding to questions. One important thing I realised early in my judging life is that I was asking questions to help myself. And some counsel I knew well in New Zealand would say, "You're being awfully tough on me." They'd say afterwards, or when we're having a drink at a party or something. And I'd say, "No, on the contrary, I need the help. I'm not there trying to put you down. I'm trying to get assistance." And sometimes, and that was true today, sometimes the questions will be designed to help you along, to move you along, and to indicate that the court might well be going partly in your way. So a really great performance all round, and I know my colleagues, not sure that we ever have a title in the International Court. And in the New Zealand courts, it's my brother judge and my sister judge. But anyway, Judge Donoghue, would you like to add to what I've just said? Or to contradict what I've just said?
Yes, thank you, President Keith. Let me just start by saying, for me, judging the Jessup is really exciting because I'm in this room looking out at all of you. Hundreds of you have spent weeks and months working on an international law problem. I mean, this is what we do all the time. And it's really exciting that you've chosen to spend so much time and energy on this topic and with such success. And I congratulate every single one of you for all the success you've had. I have learned over the years that when I see on an applicant's resume that the person has participated in the Jessup, it means that the person has learned a huge number of skills beyond just the knowledge that one acquires. And I think that's especially notable for those of you who come from traditions where legal training doesn't involve this kind of oral advocacy and mooting that is very common in the United States. So I find it especially impressive that teams from civil law countries, for example, are comfortable and prepared not only to show up and compete, but to compete successfully. And all of you deserve commendation for that. Turning to today's teams, one of the things that really struck me about all of the oralists was that no matter what questions were put to you, and even when the questions were put with a bit of an edge or dissatisfaction, none of you ever looked worried or panicked, and you might have been thinking, "Oh no, that question," but you never showed it, and you stayed very calm and did a really good job of coming back to the points that were advantageous to you, while at the same time trying to address the difficulties, and clearly there are difficulties in each of the positions that have been assigned to you, and you know that. It was also impressive to me that the teams were always prepared for the questions, and also that your initial presentations when you got up had synthesized everything you've learned so far in these proceedings. So we, for example, were given a bench memo that frankly contained some suggested arguments for each side that seemed, shall we say, creative, but ultimately not wise for a team to pursue. And it seemed that those had dropped to the wayside in the course of your preparation and advancing through this process. And I think The teams deserve terrific judgment for focusing their arguments on the points that seemed like they would be most successful for your team, and also the ones that were the best arguments for the other team, and therefore the ones that you really had to respond to here. And I think that is extremely difficult to do well, and all of you who spoke, and I'm sure your contributing team members as well, really did a great job in that regard. Congratulations to everyone in the room, including the teams.
So this is more exciting for me than for my brethren and sisters because I don't get to judge very much. I had three reactions. First, at this level, the performances are going to be extraordinarily high. And so what will distinguish one superb advocate from another is flexibility, suppleness, capacity to pivot, to react to something unexpected and flow back into your original argument and incorporate that. In other words, it's not how well you can read the music, but how well you're doing jazz. And so even among very, very able advocates, there is a noticeable difference. You watch American Idol or whatever the version is in your country, people are singing the same songs, but some people are really using it as a form of self-expression. And the people who can do that the most naturally are the ones who tend to be the most effective advocates. Point two, this is about law, but it is also about justice. And another identifiable difference is that some people can make excellent arguments quoting effortlessly sections of briefs or opinions of the court or other kinds of documents, but you're not led to the feeling that this person must win. And a winning advocate has a capacity to make their own argument sound simple and fair, and to make the opposing argument sound complicated and unfair. And the more that you can do that, most of the questions that I asked of various kinds were either, isn't your argument internally inconsistent, or isn't your argument really unfair? Aren't you masking some unfairness with your legal trickery? In fact, Judge Donoghue asked another question, aren't these statements simply inserted by lawyers to try to make something that's not fair look good? And your capacity to adapt to that and say, no, we are the ones who are being simple and fair, it's the other side that's being complicated and unfair, is a test of your skill as an advocate. And the third point goes to, again, what I think Judge Donoghue referred to, which I feel as well. It is very thrilling to be in a group like this. If there's any doubt that international law is a common global language, it's answered by this setting. And I urge you to think very strongly about this. We are so far into the history of international law that you now understand in a very visceral way that what you are doing represents the advance of human civilization. In situations where there are no common languages, where people can only react to threats and violence, there are very crude mechanisms for resolving disputes and very crude mechanisms for asserting rights. In the situation in which we exist, people can come together and make extraordinarily subtle, nuanced, and intricate arguments, and then entrust a third-party decision maker, in this case a court, to resolve these issues. And that is really an extraordinary accomplishment. Now, that's not to say that the system works perfectly, but it is to say that this system gives hope, and you all give hope to it. So you now know the language. Now is the time for you to play jazz, and now is the time for you to express arguments that are simple and fair. Thank you.
We now come to the hard part, but just before I announce the results, I'd just like to add to what has been said. Two thoughts. One is the extraordinary development that has occurred in the time since I was your age in the development of international law and international adjudication and arbitration. If you look at the reports of the International Court of Justice 40 or 50 years ago, they're rather slender things for the most part. And now the court is busy, very busy, and there are many other agencies, many other methods of dispute resolution and management and so on that have been carefully constructed and are designed to produce good results. And just thinking of particularly what Judge Coe has just said, I was thinking the other day about the first judicial oath I took a rather long time ago, and it was, and I think this is true around quite a lot of the common law world, it was to do right according to the law and usages of the particular jurisdiction. And so that's a very high calling. It's a very important part of the civilizing of relations within a state and between states. And yes, all power to you in continuing with that. Now, in terms of the two announcements, these matters are always extraordinarily difficult to achieve, and I'll give the answers we've reached, but not without the full reasoning, I'm afraid. You've already had an indication of the skills that you've got, and the margins between people and between teams are very narrow. But the winning oralist, in our view, is Ms. Zhu. And I said these are really difficult decisions to reach. The winning team is the respondent.